Morning.
Yes. Don't worry, Mr. Buck. We understand there may be a bit of disruption when your authorities arrive, and that we're only half dressed at the moment, but we'll cope with that. In order to divide the day up a bit more equally, I think what we will do is take the short adjournment at 12:30 rather than 1 o'clock. Of course, it may be that we don't need the full time that's been allocated, but that will perhaps work a bit more easily. Yes.
Thank you, my Lord. I'm hopeful we may not need all of today, but we'll see. My Lord, could I just start by picking up on a few points from yesterday? Firstly, my Lord Justice Arnold referred to a case. We think we may have found it. We think it's a case possibly called Proctor and Proctor. We don't think it assists. It's about whether A and B could grant a tenancy to A, B and C. But I think learned friend Mr. Buck may think that it helps. So what I was proposing to do was let him address you on it when he gets to that point, if that's all right. I think we have some copies. So that was that. Secondly, I wanted to come back to a question. I think it was my Lord Justice Males asked me about the judge's paragraph 75 of the judgment on page 221.
Yes.
Your Lordship remembers this was the paragraph in which the judge was dealing with the argument that Mr. Bell didn't walk away in 2011-2012, and the judge had said the agreement was made with Mr. Lampert on that basis and acted upon successfully for a year or two. It would be more difficult for Mr. Bell to walk away, and you asked me whether that was based on any evidence. Yes. We think what the judge had in mind was possibly two things. First, paragraph 60 of Mr. Bell's second statement, which you'll find in the supplemental bundle, tab 13 at page 132. So there Mr. Bell is dealing with turnover and profitability, and he says LA UK's turnover and profitability grew as we traded worldwide, including more extensively in the US. Turnover and profitability continued to rise significantly from 2011/2012. This was partly due to trading worldwide, but also due to the development of LA UK staff and exploiting new markets and building a much more significant reputation and customer base. That we think is underlying the comment about acting upon it successfully for a year or two. The company's turnover, in fact, had grown sometime around 2011-2012. The second thing is we think he may have had in mind part of the evidence from the hearing before Ms. Tipples. I hope you have somewhere in front of you a rather large A3 document which has a transcript on it. It's in A3 format because we did it in A4 and it was barely legible. Yes. And I hope the Lordships are able to see it. In fact, the second page of this document is the extract from the transcript that I showed you yesterday, which was in tab 26 of the supplemental bundle.
Oh, so I don't think I quite understood that at the time. So that was evidence not given to the judge, it was evidence given before Deputy Judge Tipples?
That's correct, my Lord.
All right, that's very helpful. And was this in evidence again before the judge, as it were?
Yes, it was, my Lord.
Yeah.
Yes. Listen, I think fairly extensive reference was made to the transcripts of the hearing.
It's not surprising, I just wanted confirmation. Yeah, thank you.
So this is the page before that, and it helps to some extent set the context for the passage I showed you. that's starting with page 17 in the top left. So this is dealing with this point about the gloves were off and the new business relationship. In other words, Inc. and UK were trading without the preferential agreement, just competing with one another potentially. And at line 6, Mr. Barden's asking, so consistently with that, you didn't understand the ownership on the US side to have changed. Mr. Bell said, as I said previously in March 2010, Mr. Frenkel at his house disavowed any ownership in the UK company. Mr. Barden said, we'll come to that discussion in a moment. But what I'm asking you now is, did you understand the legal ownership or rights on the US side had changed? Mr. Bell said, I don't recall. Then Mr. Barden said, the reality is you're carrying on trading in the UK company, aren't you? And it didn't matter to you in the end whether 50% or 51% was owned by Inc. or Frenkel or Lampert. And he said, the issue I would have had at the time was, and obviously this has transpired over the years, these two have basically been at war with each other, literally tried to stay out of it. As Ronan, Mr. Frenkel, had disavowed any ownership in the share, I thought it was fine just to continue as the existing shareholders. There is, again, a reference to him saying that with the existing shareholders, him and Mr. Lampert,
and he thought Mr. Lampert was interchangeable with Inc.
Well, yes, one sees on the next page, which is the bit I showed you, what he comes on to say. But if I could just follow it through on the transcript, that in my submission is not what he meant. So page 18, he says, if Mr. Frenkel had put a claim to his share at that stage, I would probably have folded the business because I would have had two warring partners, which would not have been very good. Mr. Barnes said, why would you have folded the profitable business? I would have folded the relationship. So you're saying you'd have put the business into winding up proceedings. Very possible. That seems a bit drastic. Probably it's what would have been if I couldn't possibly have two warring shareholders or partners on the company. But that's effectively the position you've ended up with through this litigation, isn't it? Unfortunately, yes. And you haven't folded the business, have you? No, because the company is significantly bigger than it was then. Yes, so what you've actually done is you've carried on, despite the uncertainty about who owns the shares on the US side, you've carried on, you've actually been very successful. Mr. Bell says, thank you. But so far as we can see, that was all Mr. Barden actually put to Mr. Bell in relation to this point. But he did put that Mr. Bell hadn't.
It's really lines 18 to 20, isn't it?
Yes, exactly. And so he did put that Mr. Bell hadn't walked away later, and he said, well, no, that's because the company got significantly bigger. And so...
but that's expressed in, he says, is significantly bigger, so he must be talking there about the position in 2017.
Well,
or whenever this evidence was in it. Was it 2017?
It was in 2017, Lord, yes. Yes, that's right, and that's because the question that was asked was, and you haven't folded the business, have you? And I accept that. I mean, my point is that that's what Mr. Barden put, and that's what Mr. Bell...
But of course, estoppel wasn't an issue at that stage.
Well, no.
If the implication of what you've just said is that you're suggesting he should have put something more...
I'm not criticising him. I'm just saying that is what he put. That was the answer that was given. And then if one combines that with the evidence in paragraph 60 that I showed you of Mr. Bell's statement before His Honour Judge Jarman, one can see how His Honour Judge Jarman puts the two together and reaches the conclusion that it would have been more difficult for Mr. Bell to walk away. He's got the evidence that the turnover and profitability continued to rise from 2011 to 2012, and he's got Mr. Bell's evidence that once it had got bigger and more profitable, it would have been more difficult. That's why I've referred you to that passage.
Okay, thank you.
And just carrying on with the transcript, just to finish it off. So then on page 19, Mr. Barden was putting your principal concern about the breakdown of relations between Mr. Frenkel and Mr. Lampert was that it would affect the ability of Inc. to supply UK. He repeated the question. Mr. Bell said yes. and then there was the point about trying to mediate between Mr. Frenkel and Mr. Lionput. And then on page 20, starting at line 6, Mr. Barnes said, let me suggest what he was really saying to you in the spring of 2010 was not about a shareholding interest in the UK company at all. He was actually saying he simply couldn't be part of the management of Inc. anymore. No, that's not how it came across to me. The thing is, you've got to look at it in perspective. LA UK at the time was beer change to these guys. They're very, very wealthy individuals. The money they were getting out of the UK office literally was beer money. So I don't think he certainly didn't have any visions. The company would be the size it is today. Don't think he had any vision of the company being, you know, that in 2010. So he wasn't interested. It was making distributions of profits, wasn't it? It was also retaining profits for further investment. And it was a growing business, wasn't it? Slowly. So it's certainly something that had a financial value to all of you, correct? Which is one of the reasons, I'm sure, why you didn't wind it up in 2010. You carried on with this new gloves arrangement. And then the answer that I relied on yesterday, I carried on because there was one shareholder, me, and the other shareholder, of course, was Ari. So that's why we say, and it's quite helpful in my submission to see the context in which that exchange happens and that answer was given. But we say there, Mr. Bell was clearly saying that he was carrying on because there were two shareholders, him and Mr. Lyon. And we'll see in just one moment that Ms. Tipples accepted. So that's the transcript. And then I just wanted to show your lordships, if I may, something that I should have shown you yesterday.
So suppose Mr. Frenkel in 2010 had sold his share of Inc. to Mr. Lionput. Mr. Bell would have been entirely happy with that. It follows from this evidence.
Maybe. I'm not sure that was put to Mr. Bell, but
why does it not follow from his evidence? I carried on because there was one shareholder, me. The other shareholder, of course, was Ari. So he's talking there, of course, about the shareholding in UK.
In UK, yes.
Of course. So he had no problem with Mr. Lionput's continued involvement. He had no problem with Inc.'s continued involvement. The problem, as he's graphically explained, is the war between Frenkel and Lionput. Frenkel has told him he wants nothing to do with it.
Your company.
So if Mr. Frenkel had given effect to wanting to have nothing to do with it by selling his share in Inc. to Lionput, Mr. Bell would have been perfectly content.
Maybe, but of course that isn't what happened. Mr. Frenkel remained involved, and that was why the ownership had to change. So that was that, and then I was going to show you just what I should have shown you yesterday, which is the skeleton that we put in before the judge, His Honour Judge Jarman, on the second hearing, which is in the supplemental bundle at tab 18, and it's page 233.
I beg your pardon, could you give me the reference again?
Of course, Lord. It is tab 18 of the supplemental bundle, and I'm looking at page 233. So this was our skeleton before His Honour Judge Jarman on the second hearing, and it's the section dealing with proprietary estoppel.
When you say you weren't there personally.
I wasn't
Mr.
there.
Strelitz.
It's Mr. Strelitz and Mr. Himes. Yes. By our, I meant
Yes.
Bell and
Yes. I know.
UK.
Thank you.
So paragraph 109 it is the analysis, begins the analysis dealing with the proprietary estoppel. 109 is dealing with the disavowal and its meaning. And then 110, it was submitted, that was how Mr. Bell understood the disavow, reasonable for him to understand it to be seriously intended as a promise on which he could rely. And then the court is invited to define this based on the following matters. Mr. Bell's concern at the time was how the dissolution of LA Inc. would affect UK. The disavowal came in response to that concern. Mr. Frenkel was in effect looking to allay the concerns of Mr. Bell, with whom he remained friendly. Mr. Frenkel therefore confirmed on behalf of Inc. that it would not claim an interest in UK. No other interpretation of his statement, the company is yours, would make sense. It was not a throwaway comment made in a fit of pique. Instead, it was said to Mr. Bell twice on separate occasions, almost a month apart. During this period, Frenkel was expressly holding himself out to be a director. That goes to the authority point, which isn't really an issue. And same with sub 6. And then at sub 7, Mr. Bell therefore took the Frenkel disavowal at face value, as it was intended. Paragraph 48 of his first statement states the evidence given by me in the English proceedings was that although the original agreement in 2004 had been for C1, that's UK, to be co-owned by myself and D1, that's Inc., that changed in 2010 when Mr. Frenkel twice expressly disavowed any interest in UK. Mr. Limpert and I then continued to operate UK on the express basis that was owned equally between ourselves. This is evidence.
Sorry, C1 is what?
So C1 is UK, D1 is Inc.
Right.
So Mr. Limpert and I continue to operate UK on the express basis that was owned equally between ourselves.
But the judge made no
As we know,
finding.
well, when the judge came to make his point, it was obviously after these submissions, he
Yeah.
found there wasn't an express agreement.
Right.
But that was the evidence that was before him from Mr. Bell. And then the
So it follows that to that extent the judge did not accept Mr. Bell's evidence.
well, yeah, as we see in the passage in his judgment, where he says because of the subsequent conduct, he doubted whether.
Indeed, absolutely. I was just checking that. I'm sorry, this case is so complicated.
It is.
I have to check my understanding periodically.
I'm
As you pointed out yesterday, there was one point where I got completely wrong.
I entirely sympathise. I've had the same difficulty myself, my lord. So in paragraph 8, subparagraph 8, Mr. Bell's evidence from cross-examination is set out. So he was asked, looking at the terms used, expressly disavowed, starting with expressly, in any conversations you had with Mr. Frenkel in February and March, he didn't say anything about the shares in LA UK. No, he didn't, but one thing he did convey very obviously to me, that he'd moved away from Harry and Inc., and therefore, it was my business to do what I liked, and then the actual impression I got was it's mine, so that's the evidence that the judge referred.
Now, this is cross-examination from the 2015 proceedings.
No, this is the cross-examination before His Honour Judge Jarman.
Well, how can that be if this is the claimant's skeleton argument for the proceedings before Judge?
Because this is for the second hearing. So there are two hearings in front of Judge Jarman.
Oh, I see.
Two judgments. So the evidence was given at the first one, and these.
So this is the evidence given in January 2021.
That's right. So the evidence.
Yeah. Okay.
Can I ask you this?
Of course.
The judge records in his second judgment at I've now lost it. He records somewhere that Mr. Bell gave evidence in cross-examination that he thought that Mr. Frenkel had walked away from Inc. and therefore it was just Mr. Lampert's, and that's consistent with what you've just read us to. His answer in cross-examination. He had moved away from Erie and Inc. Suppose that is what he thought. In other words, he thought Mr. Frenkel. There's a point that Mr. Barden made, saying, I, Mr. Frenkel, don't want to have anything more to do with the company, could be explicable if Mr. Frenkel had abandoned any interest in Inc. and left it to Mr. Lampert. Now, we know that's not what actually happened, but if Mr. Bell has thought that, he wouldn't necessarily have thought that Inc., as opposed to Mr. Frenkel, had given up any rights at all. What would the position be then?
Yes, if that's what he thought. I don't think that's what the judge finds, but I'm going to look and see if
It's not in his second judgment, it's in his first judgment, at paragraph 30.
But in any event, just I'm sorry to interrupt, but just before we go on to the first judgment, which I would like to go to, but before we get to what the judge found, which is obviously of importance, the point that's being put to you is, in any event, that's what your client's evidence was. And it's the passage quoted. He has moved away from Ari and Inc., and therefore it was my business to do what I liked. So what Mr. Bell himself is giving evidence to the judge is saying is that he, Mr. Bell, thought it was his business because Mr. Frenkel gave him the impression that Mr. Frenkel was moving away.
Well, I think, in our submission, I mean, maybe one can get that out of that little extract, but in our submission, one has to look at the evidence as a whole, and that's not the impression that was given. Which is
But that was the very extract that you were relying on before the judge.
Well, I see that. I see them. I mean, the reason I was taking you through those submissions was just to show you that there was evidence there from which the judge could make findings about reliance. It didn't want it to be suggested that the judge was just sort of plucking that out of the air, as it were. There was lots of evidence before him. One's in slight danger of the of Lord Justice Lewison's analogy with island hopping here, that one's looking at little snippets and extracts, whereas, of course, the trial judge had the benefit of all of the evidence and the impression that was created by all of it.
And a transcript of all the evidence given before Ms. Tipples, and cross-examination before him.
I'm sorry, I interrupted when we were just about to go to the judge's first judgment.
My Lord Justice Nugee was referring to a passage from the first judgment.
First judgment, paragraph 30, which is on page 150 of the supplementary bundle. He, that's Mr. Bell, also accepted in cross-examination before me that from 2010 he understood that Mr. Frenkel had left Inc., wanted nothing further to do with Inc., and was doing his best to shut it down. And he agreed that he was dealing with Mr. Lampert on behalf of Inc., and that these were in effect interchangeable. Now, I mean, I understand that you say there's evidence on which the judge was entitled to reach his conclusions. But we've been presented with an argument, largely from Mr. Barden, that as a full-scale attack on those conclusions has been completely irreconcilable with subsequent statements and subsequent conduct by your client and his then solicitors. Suppose the facts were that Mr. Frenkel said, I'm walking away from the company, I don't want anything more to do with it, and that Mr. Bell understood that in the sense he recorded it. I'm giving up my interest in Inc., it's for you and Ari to deal with. Where would that leave his estoppel claim? Would that be enough to sustain the estoppel argument? Because the argument you're facing is, from Mr. Barden largely, if that's what he thought, that's not enough to stop Inc. It might have stopped Mr. Frenkel, but he's not the one making the claim.
I think that the judge has found that he was making the representations on behalf of Inc.
I understand that, and I prefaced that with,
You
but you are, we're not just facing an appeal on a point of law and undisputed factual findings. There's an attack on the factual findings, which we have to face. And
indeed, of course.
There are obvious difficulties in the factual finding that he thought Inc. was giving up its interest when he later, more than once, and in quite formal settings, says it's 51% owned by Inc. That's the difficulty, and Mr. Barden laid it all out for us. We have to deal with that. So assume we come to the conclusion he's right about that, and as a matter of fact, Mr. Bell, although understanding Mr. Frenkel was walking away, and although relying on that in the way that I think both judges found, didn't draw the conclusion the judge finds that Inc. was giving up its rights. Where does that leave the estoppel claim?
Yeah, I mean, if that's the understanding, I see that there's potential difficulty there. I mean, I think I'd want to think about it because that, in my submission, at least in the second judgment, when he's dealing with the estoppel points, is not what he finds.
I have that.
And I know you.
I have that, but it is what we're being asked to overturn, that factual finding.
Well, I think what you're being asked to overturn is the reliance finding in the second.
No, as I understood it,
Judgment.
I mean, there may well be reliance finding. As I understood it, it was Mr. Barden's submission that Mr. Bell cannot have believed that Inc. was giving up its rights in the light of his subsequent statements that Inc. was the owner. That's in one sentence the case you're facing from Mr. Barden.
And that's why it said there's no reliance, precisely because that of his state of mind at the time.
And one can accept Mr. Bell's evidence, which seems to have been accepted in both sets of proceedings, that if he had understood he was going to be trapped in a war between warring factions, he would have folded the company and started again. That's not an answer to the question. Did he think Inc. was giving up its property rights in the company?
I mean, in my submission, he probably wasn't thinking as clearly in those kind of clear terms at all.
I think there's quite a lot of evidence accepted by the judges, both judges, that he never really. I mean, he's a businessman. He's not a lawyer. He's
exactly.
certainly not a corporate lawyer who understands constructive trusts and
No.
so on. I have a great deal of sympathy with that. But unfortunately, we do have to.
Yes, but I mean, because of that context, one then has to ask what Mr. Bell was actually likely to have thought, and in circumstances where Mr. Frenkel wasn't walking away from Inc., it seems unlikely that that's what Mr. Bell would have thought. I mean, there's no other evidence of Mr. Frenkel walking away. Indeed, he brought a claim to dissolve it almost immediately at this time. So it's not like he was saying, I'm just going to walk away and leave it. He was bringing a claim against Mr. Lionpert.
Well, we know that was what was in fact going on, but what's relevant is what Mr. Bell understood the position to be.
I suppose if what happened was that Mr. Frenkel said he was walking away from Inc., if that's the true understanding, and if that's what Mr. Bell understood, then given that Mr. Frenkel has authority to speak on behalf of Inc., that is a representation by Inc. that henceforth it is a company with no involvement or interest of Mr. Frenkel, which, as it turns out, is a representation which is not true because Mr. Frenkel continues to have his interest in Inc. And well, therefore, in a sense, Mr. Bell, by continuing and not winding up UK, relies on that rather different representation. I mean, I don't know if I don't know if that's a viable analysis. It may not be.
Perhaps one has to come back to what the representation actually was, which is the company is yours. And that is only really consistent with whoever is the shareholder of UK giving up whoever is the other shareholder apart from Mr. Bell, giving up its interest.
But that can't be right, because Mr. Bell understood on his own evidence, on any view, that Mr. Lionport was going to continue to be an owner of UK.
But that's because
So it wasn't that Mr. Bell thought he was getting 100% of UK.
no,
That's never been suggested.
But the reason why Mr. Lionport continues and why Mr. Bell thinks that is because Mr. Lionport was the other shareholder. He had the registered share. And so when Mr. Frenkel says, the company's yours, I want nothing more to do with it, as far as Mr. Bell is concerned, he understands whoever Mr. Frenkel's speaking for is giving up its interest. It's his company. But he knows that Mr. Lionport has got a share and he's content to continue on that basis. And that's consistent with the evidence that he gave that I showed you earlier. Yes, I'm being directed to paragraph 63 of the judge's first judgment. This is where he's dealing with the authority point. But at the time Mr. Frenkel was speaking to Mr. Bell in February and March, it was clear that he wanted nothing to do with Mr. Lyon. Objectively, he must have been speaking on behalf of Inc., as he personally held no interest in UK, whatever he may have believed. And at this time, he was in the process of dissolving Inc. in his capacity as director, financial officer, and shareholder. He confirmed he didn't suggest to Mr. Bell at this time that he was no longer a director. In my judgment, he had authority in such capacity, apparent if not actual, to speak on behalf of Inc. So he wasn't, the judge's reading of it at any rate is that Mr. Frenkel wasn't saying that he was walking away from Inc. He was not saying he wasn't a director. He was in the process of dissolving it. So it's not consistent with him just saying, I don't care about Inc. anymore, I'm going to walk away. As I say, I think one has to come back ultimately to the Frenkel disavowal, the words that were spoken. The company is yours. That's the point, and that's what the judge essentially bases his finding on.
Does yours mean you, Mr. Bell's, or does it mean you, Mr. Bell, and Mr. Lampert's?
Well, he's talking to Mr. Bell, so in my submission it means Mr. Bell's. And that's how the judge finds that he understood it, in effect. The company and business was his to do with what he liked, and that's consistent with his evidence. And what he liked happened to involve Mr. Lionport remaining as the other shareholder. He was the other shareholder already. It's up to Mr. Bell whether he continued with that position or not. He was content to do so.
Is it your submission that in those circumstances it doesn't matter whether he thought that meant Inc. had ceased to have any interest in his company, or whether he thought that Inc. was now Mr. Lampert? That's, or he didn't think about it at all?
Well, it matters that he thought that whoever Mr. Frenkel was speaking for was giving up their interest.
That's why your client's primary case before the judge at the first trial was disclaimer.
I'm not sure that was the primary case, actually, but that was the case the judge focused on. The judge picked. I think there was a list.
Well, indeed there was. That's absolutely right. It was put every which way.
Yes.
For sure. Which is precisely why one gets the result of the Court of Appeal the first time around. But nevertheless, I mean, at least I take your point. It might not have been the primary way in which it was put, but the judge, as you rightly say, certainly focused on the disclaimer, and that's understandable given the nature of the evidence, isn't it?
Yes. Yes. I mean,
Unfortunately, disclaimer
if it
doesn't work.
If that
It
had
turns
worked,
out.
yes, I'm fine. So, my Lord, I'm not sure I can help much further in relation to that. As I say, I'll think a little further on it. But we say that there was evidence there before the judge on which he could make the findings that he made. They're entirely proper, reasonable findings in the light of the disavowal, and that considerable caution is required before dipping into various bits of the evidence and reaching conclusions that Mr. Bell might have meant something different from what the judge found, given that the judge had heard all the evidence and read all the transcripts and so on. And we say, to say the judge reached a conclusion which no reasonable judge could have reached is simply unsustainable, far-fetched. There has to be some finality to this litigation.
One would hope.
We say. And Mr. Frenkel's had several opportunities to raise these issues. He's raised them lots of times. His own evidence was disbelieved by Ms. Tipples and His Honour Judge Jarman. And he may disagree with the result, but there comes a point, we say, when he just has to accept that the judge has dealt with it, and that has to be an end of it. Anyway, that was all going back to points from yesterday.
Yes, I'm sorry, I asked you a question.
No. It was my fault because I started by going there. But I was going to come on to just finish off the constructive trust. And yesterday I dealt with why we say Inc.'s beneficial interest in the two shares passed in 2010 as a result of constructive trusts arising out of the specifically enforceable agreement between the parties in 2010. And I dealt with my learned friend Mr. Buck's first objection, as I understand it, to that, which is to the effect that there couldn't be a constructive trust where the beneficial interest is being transferred to the legal owner. I'm not going to go back over that. We went through that yesterday. I was just going to deal briefly with my learned friend's second point, as I understand it, which is he says it wasn't a specifically enforceable agreement because there was no consideration. As we know, consideration must move from the promisee, so the person who claims the specific performance of the obligation has got to have given the consideration. But the consideration doesn't have to move to the promisor. And where you have what I think my learned friend described as a quadripartite agreement for parties, it frequently happens that not every party gives consideration directly to every other party, but it doesn't follow that the parties can only enforce obligations on parties to whom they've directly given consideration. And so in this case, there are really 2 points, first relating to UK and the second relating to Mr. Bell. So far as UK is concerned, my learned friend Mr. Buck accepts that UK provided consideration and that LA Inc. received consideration in the form of the release of the debt that was owed by Inc. to UK. And he says that in paragraphs 28.1 and 28.2 of his skeleton for the cross appeal, page 24 of the cross appeal bundle. Now, LA UK is a party to these proceedings, and I represent it, and it's not clear why LA UK, having given consideration, a learned friend accepts it gave, cannot enforce Inc.'s promise to convey the beneficial interests. There's no difficulty in our submission about a party who's given consideration enforcing a contract which provides a benefit to somebody else, especially where that person is also a party to the same contract and who has provided consideration in his turn. So that's the position in relation to UK. But Mr. Bell also gave consideration in this transaction. Firstly, of course, he gave up his interest in the second share to Mr. Lionpert, and that was part of the overall quadripartite deal.
It's common ground that both shares were held 49.51 originally.
That's common ground, and yes, was found by the judge and Ms. Tipples. Second, Mr. Bell procured LA UK to release LA Inc. from the debt. Of course, in reality, LA UK wouldn't have done anything if Mr. Bell hadn't procured it. And thirdly, of course, he caused LA UK to continue to trade with LA Inc. rather than just walking away and setting up a new company. So we say Mr. Bell did provide consideration in this transaction. It may be that he didn't provide consideration directly to LA Inc., but although, in fact, we say because he caused LA UK to continue to trade with LA Inc., he did provide consideration directly. If one's just looking at him giving up the interest in the second share to Mr. Lamb.
Of the three items you've mentioned, the first one I think is tolerably clear, but so far as the second and the third are concerned, why are not both of those consideration being given by UK? It's UK that releases Inc. from the debt, and it's UK that continues to trade with Inc. Why is that consideration by Mr. Bell?
He's the controlling party in relation to
So
UK
what?
At this point.
That seems to be a straightforward ignoring of Salomon and Salomon.
If he didn't agree to do that, then it wouldn't happen. So we say.
So, is it your submission, therefore, that if A is a director and shareholder of company B, and A enters a contract by which he procures that B will do something, that is promised by A? That's consideration from A?
Sorry, I've got confused as to who A is in your lordship's example.
A is Mr. Bell, the director,
yes.
and shareholder, owner and
Yes.
manager of the company, says, I agree that my company will do X. That's consideration from him personally.
Yes. And I mean, one gets that from, I think my learned friend put an extract of Chitty in the bundle. One needs authority. Yes, it's tab 30. I've been given a new list of which.
But I'm sorry. Maybe it depends on the nature of the contract, because are you saying it was a term of the contract that Mr. Bell promised that UK would continue to trade with Inc.?
That's what was agreed, yes.
I didn't quite understand that. How was that promised by Mr. Bell?
Well, he's the controlling party of Inc. I mean,
No,
either
no.
He can walk away.
On behalf of UK, he made that promise, but how was it a personal promise by Mr. Bell?
Because, as we know, in relation to the proprietary estoppel argument, Mr. Bell would have walked away if this deal hadn't happened. He would have just walked away and set up a different company. So that's why he had to be involved in this agreement. So the bit I was going to just show you in Chitty was it's at tab 33, which I think should be in volume 5. Maybe 4 for you. Volume 5 for their lordships. I think the problem has come about, and learned friends have got different volume numbers. You should have at tab 33 an extract from Chitty, and on page it's at paragraph 6-040. Promisee must provide consideration. The rule that consideration must move from the promisee means that a person can enforce a promise only if they themselves provided consideration for it. Thus, if A promises B to pay a sum of money to B, C will paint A's house and C does so, B cannot enforce the promise, brackets, unless, of course, they procured or expressly or impliedly undertook to procure C to do the work. So that's the point. We say if you procure somebody or agree to procure somebody to do
Yes,
the
but
work.
those are clearly independent parties, whereas here we're hypothesising a situation where C is a corporate party that promises to do the work, and there is a director who makes that promise on behalf of the company. The question then is whether the director is personally giving consideration as opposed to the company giving consideration.
In my submission, my lord, that will depend on the construction of the contract in the circumstances. I mean, in some circumstances, of course, you're right. When the director agrees to something, he's doing so purely on behalf of the company, and that's it. But we say this was not that kind of situation. These gentlemen were not masters of the paperwork or of the corporate structure.
It seems to me the question is not really one of consideration at all, but of whether the director makes a personal promise. If you have a written contract and the parties go to the bother of saying that the director will be a party to it, and if there is some obligation which the director undertakes to procure the company to do something, then there seems to be no difficulty there in terms of consideration. The problem arises because this is an oral contract, which is a bit of a construct anyway.
Yes.
And it's a bit hard to work out exactly who is promising what. But if Mr. Bell was making promises, I don't myself see that there's a consideration problem there. Making as it were, promises personally to do something.
Yes, and your lordship's absolutely right. That of course it is a bit of a construct, but it is accepted that it was a quadripartite agreement. They were all, that's UK, Inc., Bell, Lionperch.
Yes, but the mere fact that Bell was a party to the agreement doesn't mean that he made a relevant promise personally.
My lord, I understand that.
Your case is it fits within the bracket that Mr. Bell promised to procure the company to do X.
Exactly.
And the question is, did he or didn't he?
Did he?
But you have two fallback points anyway. One is that LA UK can enforce the contract, and the other is that he provided consideration.
Consideration of Mr. Lyon.
Yeah.
Yeah. Which
Well, I think for myself, I understand the point. I don't,
yes. Thank you.
Doesn't necessarily mean I accept it.
No, of course. But look, it's quite a simple point, and that was all I was going to say about consideration. We say plainly there was consideration in this case, and the argument that it's not specifically enforceable for that reason doesn't work.
It is quite a rare thing for contracts to fail for want of consideration, despite all the learning about it in the books.
Yes, I mean, it is a point that's quite rarely argued. And indeed, I was trying to find a case that was similar, but in fact, there's hardly any cases about consideration where you've got multi-party agreements, presumably for that reason. Although often, I suppose, they're in writing, and so...
Yes. All right, well, where do we go next?
So, Lord, all I was going to do was say, well, the effect of my submissions is that the judge's findings in relation to the 2010 agreement mean that there was an obligation on LA Inc. to transfer its equitable interest in the shares to Bell and Lionperch. That was specifically enforceable, gave rise to constructive trusts by which the equitable interests passed to Bell and Lionperch. That's an entirely orthodox application of the law laid down in Neville and Wilson. The judge didn't address it, but the point was put to him. He didn't address it because it seems he didn't quite understand the way the point was being put. But it was there, and he ought to have held that because he found the implied term, he ought to have held that there was a contractual surrender of LA Inc.'s interest. And Lord, that was all I was going to say, unless I can help you further.
Thank you very much indeed.
Thank you, Lord.
It's back to you now, Mr. Buck, is it?
Good morning, my lords. I was proposing to deal with the issue of in response on constructive trusts before then providing a reply in respect to proprietary estoppel and unconscionability. My lords, in respect of constructive trusts, we say the position is very, very simple. That is, that there's simply no constructive trust or any trust structure created as a result of what is put as the effect of the 2010 agreement in respect of Inc.'s interest. What we say in very simple terms is that on the hypothesis put forward, Inc.'s beneficial interest is simply returned to the legal owner. And in those circumstances, no trust arises. It was a simple surrender. In the circumstances where it's accepted that this was a disposition on any account, because it's not in writing, it's therefore not effective. My lords, if I could illustrate that point by reference to the first share. Mr. Bell, in respect to that first share, was its registered owner. He had legal title to it. He is also a trustee, the beneficiary of which is Inc., 51%. In layman's terms, Inc. simply returns that beneficial interest to Mr. Bell. It's a surrender. So hence, the beneficial interest, the 51%, moves from Inc. to Bell. At that very moment, because no other step is necessary, Mr. Bell then holds that share absolutely. The legal and beneficial interests have become one, therefore there's no trust. And that is the complete answer to this argument as to constructive trust. My lords, we submit, as set out in our skeleton, that concept is very straightforward. Property is held by a person, and trust only could arise in the event that there is a transfer of part of the beneficial interest or the entirety of the beneficial interest to a third party. That's the only circumstances in which a trust arises. You cannot have a situation in which a trustee is also beneficiary. Absolutely.
But how does the 51% get from Inc. to Bell? Because to the limited extent that I've understood this issue so far, the argument against you is that it's only through the constructive trust the 51% gets from Inc. to Bell.
It operates by means of a straightforward surrender of the beneficial interest.
But surrender would be voluntary, wouldn't it? Whereas the argument here is the law compels it.
It makes no difference whether it's voluntary or pursuant to a contract. The point being is that as a matter of basic law, no trust structure arises.
Well, you are obviously right that as long as it's in the same capacity, A can't hold on trust for A.
Right.
I don't think that's actually disputed as a proposition. The argument you're facing is that it follows that a disposition in writing by B of B's beneficial interest to A takes effect in law as a surrender, so that thereafter A holds the legal property in the share unencumbered by any trust. And again, I don't think that's disputed. But we know we haven't got an actual disposition in writing. That's your whole point.
Yeah.
So there's not actually been a surrender, but there has been, it is said against you, a contract for valuable consideration to surrender, which is specifically enforceable. And unlike land, oral contracts for the sale of shares are enforceable. There's no equivalent of Section 2 of the Law Property Miscellaneous Provisions Act, which makes contracts, oral contracts for the sale of shares or interest in shares, void. So you've got a specifically enforceable contract to surrender, normally a contract to dispose of specific property where you can't go into the market and get substitute property and is therefore specifically enforceable, gives rise to a trust-type obligation in the vendor to hold that property for the purchaser, even though it's not been formally completed.
But my lord, there's no. The difficulty here is there's no further step needed in respect of that. Assuming it's a contractual arrangement, there's no further step needed because all that is happening here in respect of this specifically enforceable obligation as between Bell and Inc. is for Inc. to give up or return its beneficial interest.
Okay, well, let me put it this way. Could could LA UK or Mr. Bell, depending on the consideration argument, have issued proceedings seeking specific performance of the obligation to surrender?
No, because
why not?
Because
there's a contract to surrender. Why can't that be enforced?
My lord, because it is. Assuming that there's that obligation, it takes effect immediately. It's not conditional upon anything else.
But your whole point is it doesn't take effect because it doesn't comply with Section 53(1)(c). That's the problem.
But also, my lord, it can't take effect because it's not in writing.
So what? I mean, it's a contract. It's a contract to surrender.
But my lord, in respect to the contract to surrender, it is blocked in circumstances where it's not in writing. That's simply the effect of the legislation.
That seems to be circular. What you're saying is you can't have an oral contract to surrender.
Yes. Because it amounts in those circumstances to a disposition and a surrender and a disposition and therefore surrender, and therefore it has to be in writing. That's the effect of the legislation.
So you are making the same submission that Mr. Wilberforce QC made in Orchard.
Yes, my lord.
Yeah.
And it's a point, my lord, identified within the Australian authorities that you have this fundamental difficulty that you can't have a situation in which a trustee, so there's a trust arrangement, trustee A, beneficiary B, and B then simply returns that interest to A. That doesn't create a trust. It's a surrender.
So the contract is what, void?
Yes, my lord.
What about the other terms? I mean, there are other terms to this contract.
May I just take? I think, my lord, if I could rephrase my answer, I think the point being is that the contract doesn't give rise to a constructive trust. That obligation is there, but it doesn't give rise to a constructive trust.
And can't be enforced?
Well, my lord, I would ask the question, how could it be enforced? I mean, what step would have to take place in order for it to be enforced?
Well, straightforward vendor and purchaser summons asking for specific performance of a contract to surrender and an order that a proper surrender be executed.
But that's not.
I mean, I have difficulty in the notion there is a contractual obligation to surrender, but it can't be enforced. And if it can be enforced, then I don't see why it doesn't give rise to an obligation of constructive trust type in the normal way.
My lord, what we say is essentially it is the wrapping up of a disposition in the form of a contract.
Yeah.
In circumstances where that therefore is then used to overcome the formality difficulties. And the difficulty is his lordship, the judgment doesn't address this in the sense that he doesn't address it, but the difficulty is that the claimants are seeking entitlement to the declarations they sought, where that simply isn't available to them.
So the way you've just put it sounds like a submission based on purposive construction of Section 53. Is that what you're saying? Purposive construction of Section 53. Because you seem to be emphasising that this is an argument to try and get round the requirement for formalities.
That is what is being put, my lord. Can I just make it very clear? We are not saying that A, a trustee, where there's a B, the beneficiary, that B, the beneficiary, cannot transfer their interest to C.
Yeah,
Which
so
is
it's
what happens
different
in-
if it goes back to A.
Quite, my lord. So there's no issue with Neville in that respect, to the extent that Neville satisfies that. There is the issue with the four widows, the shares of the widow and the four shares. And there's no issue with Singh and Balki. The problem, my lords, is that you can't have a situation in which a trustee is receiving back the beneficial interest, not in writing, so therefore it avoids the requirement for that agreement to be in writing.
All right, but that's why you're reluctant to accept my suggestion on purpose of construction, because if that were the right answer, then that would query whether one could do it in the ABC case.
Yeah.
So it's not really about Section 53. It's about something more fundamental.
Yes, ma'am, that's correct. I don't know whether your lordships have had an opportunity to look at the two Australian authorities on this point, or they touch upon it in the dicta there. It was set out in the skeleton argument. I don't know whether it was.
Speaking for myself, I would find that helpful to look at them now.
My lords. They are, I believe, in Authorities Bundle 4. Actually, I think Authorities Bundle 5. I apologise. Behind tab 30, my lords. I do hope that reference is correct. Starting at the head note on internal page 431, this was a case concerning a transfer arrangement between an original owner of property to an associated company, where that associated company was to be a trustee holding beneficial interest on behalf of the original owner, so the original transferor. The question arising was whether stamp duty was payable on the transfer of the land to the intended trustee. My lords, an ingenious argument was put forward and was dealt with as a preliminary issue, a preliminary argument. And if I could ask your lordships to turn to page 463. And it was an argument advanced by company DKLR, which was the original, was the intended trustee. Was the original owner to be transferred to 29 Marquee, which was to be the trustee. And what was suggested, was that what was transferred was not the legal title and the beneficial interest, but was merely the transfer of the beneficial interest. And that was an argument rejected. We say that's a very simple point, but applicable in this situation. My lords, in respect to Corin, which is in the next tab, tab 31. This concerned the intended transfer by a joint tenant of her interest to a trustee, for that to then be held by that trustee for her benefit. She died before the transfer was registered. And the question was, on the facts, whether that amounted to a severance of the joint tenancy. My Lords, if I could ask you to have a look at page 578, you will see the argument as put by the joint tenant, and that's at the bottom, my Lords. Beginning, it was submitted. The submission that equity should give effect to the intention, which was that the trustee would hold the property on trust, subject back to the Mr. Corrin, their trustee. My Lords, the point of relevance is over the page. There were several reasons why that argument was rejected, but it's the third answer over the page at 579, beginning the third answer is that equity, with its regard for substance rather than form, would not go through the charade of intervening to create trusts of property on which the legal owner held as bare trustee for another, who in turn held as bare trustee for the legal owner. Carrying on to the bottom of that paragraph. We are not aware of any authority in this jurisdiction to the effect that a trust arises in circumstances where A, as a trustee to B, B being the beneficiary, and then B then returns that beneficiary interest to A, that becomes a trust. The only point, my Lord, is in respect of Neville and the widow's 4 shares. However, we say, as your Lordships noted, that was not an argument that was identified, discussed and determined within Neville. So we submit that Neville is not authority for A to B and back from B to A. As stated earlier, we have no issue with A to B to C. That's not what we're dealing with here. Your Lordships also commented upon, and you will have seen the academic criticisms of the decision in Neville.
But is the academic criticism founded on the ABA point, or rather upon the failure to analyse the corporate structure properly?
It's the latter, my Lord.
Right.
We say there's certain difficulties with the case, but on any account it doesn't deal with this issue of ABA.
Yeah, but does the academic criticism deal with the ABA point?
No, my Lord.
Right.
My Lords, there is a potential way, if your Lordship considers it necessary or desirable, to potentially deal with the issue of the 4 shares in Neville. Our primary position is that Neville doesn't deal with this, so therefore it has no relevance and application. But one potential interpretation of Neville, I say this not on the basis that it's not strained, because it is strained, but within Neville you had a situation in which the issue concerns the 4 shares. In this ABA situation, it concerns the 4 shares that were held by the widow. So the widow is the trustee. There is the corporate personality issue, but ignoring that, what's said within, or the way the judgment reads, is that the beneficiaries of that trust were the shareholders, which did include the widow. and that there was then a transfer by the widow to the trustees, including herself, and specifically in respect to the 4 shares, and therefore a constructive trust arose. My Lords, if I could take you to Neville, which is in the First Authorities bundle. Behind tab 11. What we do know in respect of Neville is that the trusts, and I say there was 2 trusts, we have the widow as a trustee in respect of 60 shares. We then have Mr. Wilson, who is a trustee of a separate block of 60 shares. We do know that the 4 shares, their 4 shares were transferred to the widow. It doesn't have to be the case that those 4 shares transferred, or the beneficial interest in those 4 shares, were the shares held by the widow herself. But it could have been the shares held by Mr. Wilson. So you essentially have a swap of beneficial interests, but under different trusts. I fully accept that's a clunky analysis, but my Lords, if I could ask you to turn to page 154, it is a potential interpretation of Neville. Page 154 internally, G. We are therefore of the opinion that in about April 1969, the shareholders of Gen entered into an agreement with one another for the informal liquidation of Gen and for the division of Gen's equitable interests in 120 ordinary shares in UEC. Those are 120 shares, 60 to Mr. Wilson and 60 to held by the widow. Over the page at 155 at B, the effect of the agreement more closely analysed was that each shareholder agreed to assign his interest in the other shares of Gen's equitable interest in exchange for the assignment by the other shareholders of their interest in his own share. So it could be suggested that that's a reference to a simple swap. Further on at F, it said the simple view of the present case is that the effect of each individual agreement, so there's a whole series of individual agreements between the different shareholders, was to constitute the shareholder an implied constructed trustee for the other shareholders. And then further on, my Lords, at page 157G, we do not think that there is anything in the speeches of the House of Lords which prevents us from holding that the effect of each individual agreement was to constitute the shareholder an implied constructive trustee for the other shareholders. If one was to interpret this case and the 4 shares in those circumstances, you don't have an A situation, you have an ABC situation. Because it's Wilson to another shareholder to then to the widow. As I say, my Lords, it is. I don't present that as a beautifully consistent and argument, but it is one interpretation of Neville. The alternative position, my Lords, is that Neville didn't consider and address this issue of ABA.
But if that was what was in the Court of Appeal's mind, it might explain why the ABA point wasn't considered.
Yes, quite. One can see.
So although it doesn't leap off the page, if that was in truth the thinking, it explains why what is otherwise slightly hard to explain, as being one would have thought an obvious point to at least discuss, is not discussed.
Yes, quite, my Lord.
Although if that's the reason they didn't discuss it, if it is an obvious point to discuss, they might have said, we don't need to consider this. Who knows? Who knows? Who knows?
moving on to the issue of consideration. We don't accept that there has been the provision of any consideration by Bell to Inc. in circumstances where Inc., we say, surrendered its interest to Mr. Bell. But that is in truth what has taken place. Mr. Bell was clearly acting as a director of UK. And there's certainly no findings that he undertook any personal obligation in that personal capacity in respect of the events of early 2010. And when I was describing in my opening the events of 2010, I was making it clear as a quadripartite as a matter of fact, in the sense that there were 4 parties involved. I was not conceding or suggesting that there was an enforceable arrangement which did involve Mr. Bell. As we submit, there wasn't. It was a question of the trading relationship between Inc. and UK.
Was he acting solely in his capacity as a director or also in his capacity as a shareholder of UK?
The difficulty with that, my lord, is that his position as the registered shareholder is not altered by anything in respect to 2010. And this is a point that wasn't put below, and obviously therefore wasn't dealt with by his lordship. So in very simple terms, in that
I'm sorry, you're going to have to explain that to me. It must have been the claimant's case before the judge that there was consideration because they were arguing for a contractual surrender. I'm sorry, so they were arguing for a constructive trust, and it was footed on the basis of an enforceable contract. So it must have been their case that there was consideration.
There was no consideration in respect to the issue of
No,
consideration.
no, it must have been their case that there was consideration.
Yes,
Otherwise,
implied.
how would they have an enforceable contract?
Yes, well, I accept that implied within that was the case. But what I'm saying is there's no findings that there was a legal obligation binding Bell personally.
Right, so the submission you're making is that it was not put below that there was any personal obligation undertaken by Mr. Bell such as to amount to consideration. Okay.
Is it your submission the quadripartite contract as a whole was unenforceable and void for lack of consideration?
Our submission is that there's not a quadripartite agreement in the sense that there's 4 parties to a contractual arrangement between the 4 of them.
No, but the judge has clearly found there was a contract. He's
Yes,
found an
my lord,
implied
I
term in the contract. As I understood it, it's not disputed that there were at least terms in relation to giving up debt, continuing the trading arrangement, etc., etc. Is all that enforceable?
Well, my lord, just in respect to continuing the relationship, it's never been put that there was an actual express term or an implied term, that there was an obligation to continue to trade.
Okay. Well, the judge did find a contract. Well, I thought that there were certain terms which weren't really disputed. Where's his finding in relation to the 2010 contract?
paragraph 48, isn't it?
I mean, he starts the discussion of contractual surrender at 36, where he refers to the 2010 agreement as if that's something which has already been established.
I think, my lords, that's in the sense of not that there's identified a specific contractual framework there, but the 2010 arrangements are the discussions that took place between Mr. Lampert and Mr. Bell.
All right, well, this seems to be a fairly fundamental point you're making here, which is what was the contract, who were parties to the contract, what were the terms of that contract? So let's start from question one. Are you submitting that there was in fact no contract at all between anybody? Because you seemed to be suggesting a moment ago that the expression, the 2010 agreement, is just a label for some arrangements which don't necessarily have contractual effect at all.
Yes, my lord, because we don't, obviously, as part of what we say, is we don't say that there's the implied term. So the only contractual obligation arising on the judge's findings is an implied term, implication of a term.
You can only imply a term into a contract. You can't create a contract by implication. But I'm sorry, I need to be clear what your submission is here, because there's two different possibilities. It's one thing to say that to the extent there was a contract, Mr. Bell was either not party to it, or even if he was party to it in name, he undertook no obligations. It's another thing to say there's no contract at all.
We said there's no contract at all, in the sense that that there was a discussion.
But I'm sorry, but then that would be your ground of appeal. It wouldn't be this contract is unenforceable so far as Mr. Bell is concerned because he gave no consideration. It would be there's no contract.
Yes, my lord, I recognise that.
Well, I'm looking at paragraph 50 of his first judgment. It's a bit difficult having to dot around. But in paragraph 50 of his first judgment, he cites an agreement between Mr. Bell and Mr. Lampert, as part of which Mr. Lampert agreed to assume responsibility for what Inc. owed UK. Now that looks like a contractual agreement. He says the evidence on this was not challenged before. And then when he comes to his second judgment, paragraph 39, he refers back to that.
I do apologise, my lord. I have to change the position in the sense that there is an agreement for the release of the debt. And
So there is a contract.
I do.
There is a contract in 2010.
Yes.
So the question is, who are parties to that contract?
In respect to the exchange of obligations, that was between Inc. Lampert, and it would have to be UK. Because
Right.
UK is releasing Inc.
Yep.
And Mr. Lampert is then taking on that debt.
Is your Bell is not
Bell is not a party to that.
Bell not a party. Are there any other
No.
express terms of that contract? Well, agree to work together to carry on UK's business. That looks like some sort of agreement between Mr. Bell and Mr. Lampert.
Well, that would assume that Mr. Bell was talking in his personal capacity. And the point, my lord, is in respect to the evidence, what you had is Mr. Bell concerned about ensuring that Inc. and UK would continue trading, that there would still be that commercial relationship ongoing. And it's in that context we would say that there was any discussions about Inc. and UK carrying on trading. But my lord, that's one issue. The second issue is, can that amount to a contractual term, a contractual obligation?
Well, and presumably it's not suggested that UK is bound continue to trade with Inc. forever.
Because, my lord, the point of it was the gloves off comments. That now they were free to compete against each other. The gloves were off in circumstances where previously there was an agreement of non-competition. So what's essentially happening is there's an agreement that the agreement is that
the non-competition clause goes.
Now the gloves are off, they can carry on trading, if they so wish, on normal terms, gloves off.
And that would include not trading.
Yes, my lord. Well, it wouldn't be the difficulty is whether the outcome of the release from the 2004 agreements, the two clauses in respect of relevant clause in respect of preferential trading, whether the release of that then is then replaced by a positive obligation or some other obligation, that they are then to trade together.
Well, what they do is they terminate the preferential arrangements which had previously applied to their trading, and for the future they will trade on ordinary terms.
Yes.
But they're not undertaking any particular quantitative obligation or anything of that nature.
And then he also seems to find, I'm now looking at paragraph 46 of the second judgment, there was an agreement to divide profits equally.
Well, my lord, the difficulty with that is whether that is tied to the issue of ownership or not.
No. At the moment, I'm trying to understand whether it's your case that was agreed and was part of the contract.
What's the answer?
So, my lord, in respect of the position, as obviously in 2004 there was an agreement in respect to the distribution of profits. And that is an arrangement which does alter in 2010. This is in circumstances where the payments of those profits are made by Inc., not made by UK, forgive me, my lord. So the point of the 2004 agreement is that the profits of UK are going to be distributed 50-50, and UK then distributes those profits.
So is that an agreement that forms part of the contract that going forward, instead of the provision we had in 2004, from now on, the profits of UK are to be split 50% to Mr. Bell and 50% to Mr. Lampert. That's part of the contract. Yes. Is Mr. Bell a party to that? He's not. It's just an agreement between UK. And
yes, my lord, because it's UK's.
Well, I know it's UK's profits, but the owners of Mr. Bell's at the very minimum a 49% owner of the company. Is he not interested in how the profits are distributed?
I would recognise he would be interested, my lord.
But you say he's not a party to that contract. So is it your submission he wasn't really a party to this agreement at all?
Yes, my lord. And if that's wrong, and he was a party to the extent of agreeing to a reformulated distribution of profits,
right,
which is distinct and separate from what we say is the surrender of Inc. of its beneficial interest.
I understand it's a separate point.
It is, yeah.
I think we've got to a stage where we've established what you accept the actual terms of the express terms of a contract are. They're dealing with the debt, which is going to be assumed by Mr. Lampert instead of Inc. Yeah. They're dealing with the preferential trading arrangements, which are going to go, and they're dealing with the profits, which are now going to be split 50% equal.
Yeah.
Those are the three elements which I think it's not disputed a part of that contract. There's a dispute as to whether Mr. Bell's a party to any of that.
Yes, my lord.
Then we have the fourth element, which is the implied term. At the moment, you're addressing us on the assumption that there was such an implied term.
Yes.
The implied term is that the shares will be held beneficially in the same proportion as the profits, i.e. 50% each,
Yeah.
which effectively means each share is held legally and beneficially by the shareholder. The shareholder.
Which is the point.
Which is the point. Is Mr. Bell interested in that part of the contract? I mean, he plainly is, isn't
Yes.
he? Yes. Right. So your point is simply that he doesn't give consideration for that part of the contract.
Yes, my lord.
Right. I think I now understand where we are. Right. Thank you.
Thank you. My lord, you've seen our submissions in respect to the provision of consideration. In the absence of any further points that you wish to address me on in respect to the constructive trust, I was then going to move on just to provide a short reply in respect to...
Well, can I just ask you about the other point that Mr. Trigger made this morning, which is that even if Mr. Bell didn't give consideration, LAUK gave consideration.
Yes, that's exact.
And that means that if there is, as he says there is, a specifically enforceable contract to surrender, LAUK can enforce it for the benefit of Mr. Bell.
Yes, my lord, I accept that.
Well, then does it matter whether Mr. Bell gave consideration?
Sorry, my lord, can I just... My lord, do you mind if I just have a review of an extract from Chitty?
Of course.
Thank you. My lord, just on this issue of the enforceability, can I just raise with the court a comment within Chitty as to whether that is possible? Could I ask your lordships to turn up, please, tab 33. My lords, it's in 6-043. At the bottom, raising the question as to whether, in all circumstances, a promisee specific performance will be available in respect to a promisee. I do recognise, my lords, that there is not before you the paragraph 644 to 646.
It seems to me we're getting into quite recondite areas, but I think this is a slightly different point.
Yes, I know.
If A and B are the benefit of a promise by C, the question addressed here is whether, if all the consideration comes only from B, A can enforce the promise. But I think the way Mr. Twigger put it is a slightly different point, which is that A, that's LA Micro UK, is the benefit, has the benefit of a promise by B, that's Inc., to surrender its interest to C, that's Mr. Bell, and that A can enforce that promise for the benefit of Mr. Bell. And that's a sort of Beswick and Beswick point, and I think you're probably right about that.
Yes.
Yes. So I don't think this point
I
is
don't
quite the same point.
Yeah.
Yeah.
My Lord, if I move on to the issue of proprietary estoppel in reply. Just certain short points in response to what my learned friend submitted yesterday. In respect of paragraph 34 of the first judgment, my Lords, that's at page 151, the supplementary bundle. There is the judge's findings as to what is said to be confusion on the part of Bell. My Lord Justice Arnold asked Mr. Twigger as to what that confusion related to. And my understanding from the claimant's position is that what is being said, as a matter of fact, is that between 2010 and 2012, Mr. Bell's state of mind was clear in that Inc. had surrendered its interest. And we say, as submitted yesterday, that's necessary finding in order for the proprietary estoppel claim to work. What's then said is that 2012, Mr. Bell enters a period of confusion, emerging some point post Tipple's judgment in 2017 and prior to the issue of these proceedings in 2020. And that he then now has a clear position that he understood in 2010 that Inc. was giving up its interest. And what's said is that paragraph 34 is referring to that intermittent period, the 2012 to some point beyond 2017. The short point, my Lord, is that is clearly not the case by reference to paragraph 33 and specifically the middle section. The confusion rises in respect to the legal consequences rather than what Mr. Frenkel told him. So, my Lord, what the judge is doing is saying there's no confusion in Mr. Bell's mind as to the actual words used by Mr. Frenkel in the disavowal. The confusion arises as to what that means. And that's confusion in Mr. Bell's mind. And that is the confusion that is referred to in paragraph 34, which is in 2010, the final two words of paragraph 34. So we have a clear finding we submit from the judge as to Mr. Bell's state of mind in 2010, which we say therefore is directly relevant to the argument on proprietary estoppel, which has to be, in order for that claim to succeed, that Mr. Bell did believe, had actual knowledge or actual belief, that Inc. was giving up its interest. My Lords, this morning you raised questions as to what was the position in respect to proprietary estoppel if Mr. Bell understood matters differently. For example, that Mr. Frenkel was walking away, and walking away, for example, from Inc. We say that that would not be sufficient for a proprietary estoppel claim to succeed. The property affected by the assurance has to be Inc.'s beneficial interest in UK. We say that there has to be an actual state of mind on the part of Mr. Bell that he understood and placed reliance on the fact that Inc. was walking away from that interest, i.e. its interest in UK. My Lords, you are also taken to the judgment of Justice Tipples as she is now, paragraph 109, which which is located within the supplemental bundle at page 78. And again, as I understand the submission of Mr. Twigger, what was being said was that this was good evidence of what Mr. Bell actually thought the position was in 2010. And that you could therefore, and the judge was entitled to place reliance on that evidence. The difficulty, my lords, is that Mr. Bell can't have it both ways. This is evidence he's giving in circumstances where you're also being told that in this period 2012 to at some point after this judgment is handed down, Mr. Bell's mind is confused. Therefore, when he's giving this evidence on his own case, he must have been confused. And that is the argument put forward to say that paragraph 34 of the first Jarman judgment is a reference to confusion periods 2012 to 2017. The point being is that Mr. Bell can't have it both ways. Either in the period 2012 to post this judgment he's confused, or he's not. If he's not confused, essentially, my lord, his position and his evidence moves around continually. And my lords, the submission I made yesterday morning was that there was a fundamental inconsistency within the judgment in respect of how the judge had used the subsequent conduct to determine matters of fact. My lords, I submit that in determining whether there was express discussions between Mr. Bell and Mr. Liampert as to ownership, the judge placed reliance upon the subsequent conduct as informing that finding that there was no express discussions. That, I submitted, should be compared to then how he dealt with the factual issue arising at the same time, or whether there was any actual, as a matter of fact, reliance by Mr. Bell on the Frenkel disavow in the way that was necessary. And I submitted that the judge dealt with those matters inconsistently. That's a point that Mr. Twigger has not, I submit, addressed to your lordships. The fourth point, my lords, is in respect of the judge's actual treatment of the issue of reliance in paragraph 75. It was accepted yesterday that the judge had simply inferred reliance and had cited no evidence in support. This is a point addressed within our skeleton argument, the supplemental skeleton argument contained within the supplemental bundle on the cross appeal, paragraph 46.3.3, which is in the bundle at page 131. Now, forgive me, my lord, it's in our first skeleton argument, 46.3.3, within the core bundle, tab 3, page 131. And we set out there the fact that there was actually evidence contrary to what was said to be inferred, i.e. the success of the business, and I invite your lordships to consider that evidence. More fundamentally, my lords, we say that there's no actual evidence to support a finding of reliance by Mr. Bell to the extent necessary in order for him to succeed. What was said by Mr. Twigger yesterday, well, the existence of inconsistencies only takes one so far. But the point, my lords, is in the situation where there are those inconsistencies, and to the extent that they are to be resolved, which we submit they should be resolved, one can place reliance upon the subsequent conduct as outlined by Mr. Barden to give a basis for a finding as to the absence of any reliance, or to look at it another way, that the claim pursued has not been proved that there was such reliance. And my lords, we also submit that that approach, by referencing the subsequent conduct, is in fact consistent with how the judge dealt with matters of fact, both within the second judgment and would also be expressly referable to the finding in the first judgment at paragraph 34. that there was confusion on the state of mind of Mr. Bell. My Lords, those are my submissions in respect to proprietary estoppel. I believe Mr. Bond is going to deal with some aspects of the subsequent conduct, so I won't go there at this stage, my Lords. Unless I can assist any further.
Thank you very much. Gordon?
My Lords, there are 5 things I wanted to deal with. One was a point raised by my Lord Justice Nugee yesterday about why are we here, and there was one additional thing I need to say about that. Secondly, something quite brief about the trust point, where I just want to show your Lordships how the contract was pleaded. Then there's the question of Mr. Bell's evidence in 2017, on which Mr. Twigger made some submissions yesterday, and your Lordships asked whether we had his witness statement. And the answer is we do. There's then the question that was raised briefly this morning, although I didn't sense Mr. Twigger was enthusiastic about it, about the idea that Mr. Bell might have believed something different than that LA Inc. was giving up its interest. And then finally, there are Mr. Twigger's points about the judge's approach and the overall approach to the evidence. So, on why we're here, in the sense of Mr. Frenkel, the point I made yesterday was that Mr. Frenkel had been joined, costs had been sought and obtained against him. The point that I didn't make but should have made is, of course, that my Lord's point that one could recover the money in any event if Mr. Lampert sells the share runs to the extent, but only to the extent, of the amount of the judgment debt against Mr. Lampert, which is approximately $4 million US. Right. If the share was sold for more than that, which on my client's evidence in the US court it should be, then obviously there would be a surplus amount. And the outcome of these proceedings potentially determines the allocation of that surplus, because...
You retain a 50% interest in LA Inc.
Exactly.
Are there other creditors of LA Inc? I mean, if there's recovery... I mean, I understand that Mr. Frenkel is not giving instructions on behalf of LA Inc. There's an independent... I don't know what his title is, but there's an independent practitioner of some sort acting for LA Inc. who's instructing Mr. Burke.
Yes.
But in practical terms, if LA Inc. wins these proceedings,
yes,
you have to pay the costs of whoever the practitioner is, and then there are some debts to pay, tax to pay.
Yes.
And then ultimately, it ends up being split 50-50 between you and Mr. Lampert, subject to the fact you've got a $4 million judgment against Mr. Lampert.
Exactly, my Lord.
Yes, I see.
So if the price is higher, then the surplus is higher. So that was a point I should have made yesterday and didn't.
And would I be right in guessing that the IRS is a preferred creditor in the US in the same way as HMRC are here? I mean, obviously I'm not asking you to give expert evidence as to US law, but it seems likely.
It may be the case. I don't know. We do know that Mr. Yepremian, who is the independent director, I think is his title, court-appointed independent director, he gave evidence that there was a tax creditor. And I don't know to what extent the amount of tax owing changes if the share is sold. Presumably it may do.
Yes, there might be a US income tax in the nature of CGT if there was a sale. We don't know. It's not before us. It's not
exactly.
But is it a fair summary that LA Inc. is not doing any business? Its business is this litigation, but it is using this litigation in order to recover, if it wins, enough to pay off its creditors and divide the balance between you and Mr. Lampert, subject to your judgment debt against Mr. Lampert, and there's enough money potentially in it for you to end up with more than just the judgment debt.
Yes, that's right, my Lord.
That's very helpful.
That's exactly the point. Then in relation to the trust point, I wondered if it might be helpful in relation to what the contract is to have a look at the way it was pleaded in the particulars of claim. So this is tab 13 of the core bundle. No, I'm sorry, it's not tab 13, it's page 239, so it's tab 12 in fact. Do my lords have their paragraphs 26 and 27?
Yes.
So the way it was pleaded was that Mr. Bell and Mr. Lyampert agreed the new arrangement that were Inc. to undertake any trading with UK in the future. So pause there, definitely not put as an obligation to continue trading, but merely these would be the terms if they did. And then you see 3 terms set out there, which are usual margins, freedom to compete, and no pooling or sharing of profits between them. So those are the terms that have colloquially been described as gloves off. So that is in fact all that I can see is pleaded as an agreement. There is then paragraph 27, which says that the new arrangement was reached on a common understanding that Bell and Lyampert were the 2 undisputed sole shareholders. And it's that alleged common understanding, as I read the judgment, although it's, with respect, not that clear, but it's that alleged common understanding which appears to be elevated into the implied term, even though it's not pleaded as such. And we say, of course, a number of things about that. First of all, you can't elevate that into an implied term because it's not necessary or obvious from what is agreed in paragraph 26 about the change of the trading relationship. It's not a necessary or obvious implication of that what is pleaded in paragraph 27 becomes a contractual term. And secondly, of course, you have my main point, which is that alleged common understanding is directly contrary to the detailed subsequent conduct. So that's the first set of points on the contract. The other set of points that arises from this is on the constructive trust point. So if your lordships were not with me on that and were to agree with the judge that paragraph 27 does become an implied term, in my submission it's important what the implied understanding or the implied term as found by the judge, this is paragraph 48 of the judgment, actually is. Because what it is, first of all, the way it's pleaded is an understanding that they already held in those portions. And then if one looks at paragraph 48 of the judgment, which is on page 213.
Sorry, already held before what?
Well,
This is
the way
the
this
understanding
is pleaded,
as a result of the Frenkel disavowal, isn't it?
yes, that appears to be the way it's pleaded, yes.
Yeah, okay.
And the finding then at 48 of the judgment is that it was a necessary implication of the agreement that the shares in UK would thenceforth be held in the same way as the profits were to be split. So it's not, either in the pleading or the judgment, found to be an agreement for some future transfer. It's not like the analogy of a sale of land or indeed anything else where there's a conveyance, where one has an agreement to buy or sell, and then subsequently some step which is taken to complete that agreement. what's actually found is that they were agreeing, it seems, from that moment, that they were holding the shares in those proportions. Now, obviously, to be clear, we say that's not an implication the judge should have made at all, but on the constructive trust point, we're proceeding on the basis that he has made it. And that's important in relation to the constructive trust analysis in my submission, because there is a difference between a contract to dispose of property in the future, dependent upon some condition, such as the payment of a purchase price, or simply to do it at some specified future date. And it's in that case that a constructive trust arises in the period between what one can colloquially call exchange and completion. Where in my submission a constructive trust doesn't arise is where you have a purported immediate disposal, which is not conditional on any future action or event, but which simply fails for a lack of formality. And what in my submission the respondent's argument seeks to do is to turn a purported immediate disposition as to these are what the shareholdings are as of now into a promise to dispose in the future, and thus to magic up a constructive trust which circumvents formality provisions.
Isn't that exactly what happens at common law, where there's an informal mortgage by way of deposit of title deeds? It doesn't take effect as a legal mortgage, obviously, because there's no conveyance.
Mm-hmm.
But equity treats it as a contract mortgage, and that, because equity will look on that as done which ought to be done, because it's specifically enforceable, will therefore give rise to a mortgage which is valid in equity. What's the difference?
The difference is that in the case of the mortgage, there is an element of, more than one difference I suspect, but there is an element of futurity or conditionality about that.
No, I mean, the deposit of title deeds takes place against the payment of the money it's intended to provide, and it does,
yes,
in fact, provide immediate security. And the reason it provides immediate security is, although it's completely ineffective at law, in equity it's treated as a contract to grant a mortgage which is specifically enforceable, and that's good enough.
Yes, but what the parties are agreeing in that situation is that the deposit of the title deeds will create an enforceable right going forwards. Whereas in this case, there isn't any such agreement. All they're doing is purporting to dispose now. And if one took the approach which is contended for, then the effect would be that these formalities provisions could never bite on any purported disposal which was for consideration.
Yeah.
They would only invalidate a gift which was not made in compliance with formalities. And in my respectful submission, that isn't something one gets from the provision. If one had wanted to draft a provision that dealt only with disposals not for consideration, the draftsman could and would have done that in a much more direct and straightforward fashion. And so in my submission, what one can't do is strain the analysis to create a constructive trust based on some implied future promise when that isn't actually what's happening. What's actually happening is a purported immediate thing which doesn't work because of the lack of formality.
And that again is the essence of the submission made by Mr. Wilberforce QC in Order.
Yes, it is. It is. I'm not sure that my submission here necessarily goes as wide as the submission made in Orchard.
But the underlying reasoning is essentially the same.
Yes, it is. Yeah. The essence of the point is the same. It's that one can't. But the way I would put it is that one can't read the statute as only applying to gifts.
Yeah, but I mean, he's not recorded as having put it that way, but that's the underlying logic. Yeah.
Yes. The third of my 5 points was in relation to Mr. Bell's evidence in 2017, and for this I do need to hand up the witness statement which my lords were asking about. So I think the reason this was asked about yesterday was in the context of the evidence which Mr. Bell gave in cross-examination in 2017, which I won't take your lordships back to, but you'll recall my submission on it, which is that it was very clear that he was corroborating and repeating what he'd said in the United States and what he'd said in his pleading and other places. There are just a handful of paragraphs which may be of potential assistance. The first is paragraph 24. And this just goes to the point about the original profit sharing. So he's talking about the position prior to 2010 here, obviously. And making the point that the distributions were paid directly to the individuals or their investment vehicles. And Mr. Bell says, I felt comfortable with this because I knew that they were 50-50 owners of Inc. And if that was the way they chose to structure the receipt of the share of the profits, I had no problem. So clear from that he understands that he's dealing with Inc. But he also understands that it's possible to separate the way the profits are divided from the legal shareholding. The second paragraph I wanted to show you, which is also about his pre-2010 understanding, is paragraph 56. So he's talking here about the discussions he'd had with Mr. Liampert about establishing the arrangement in the first place. And he says, I felt I was getting into business with Inc. My understanding of the deal we had done was that it was a permanent one and not subject to either Roman's or Ari's continued involvement in Inc. That had never been mentioned to me. I had not factored into my consideration what would happen if one or other left Inc. As far as I was concerned, I think I would have assumed that the company would have carried on with Inc. and that profits would still have been distributed in accordance with the expressed wishes of the owners of Inc. So he's making very clear there that his pre-2010 understanding was that the shareholder was Inc., that Inc.'s position as shareholder was not dependent one way or the other on the individual positions of Mr. Frenkel or Mr. Liampert, and that if there was some parting of the ways, his expectation was that LA UK would continue with Inc. So that's completely consistent with the understanding that he, or in my case, had in 2010 and said in 2012 and subsequently that he had in 2010, namely that Inc. remained the shareholder.
But he's giving evidence here about what he thinks he would have thought, rather than what he did think.
Well, indeed, but the problem for my learned friend is that that's pretty much the highest his case can go in terms of there being a basis for the judge's finding. Because... so all I'm saying here is if we're playing the game of what did Mr. Bell say he thinks he would have thought, then it actually looks like even if we play that game, he would have been pretty clear in 2010 that he understood Inc. was the shareholder. As you know, I say you don't play that game, you look at what the clear documents say.
Yeah, and in paragraph 60 we get a quite interesting statement of his overall view, which is he's frustrated and concerned at being dragged into a dispute between Roman and Ari, resents the expense and inconvenience to himself and UK, and that says what should have happened is that he would have had 49% of the shares in UK and Inc. would have 51%. Well, yet another statement in accordance with ones you relied on yesterday.
Well, indeed, and one sympathises with his frustration, but this is important actually because it goes to the point that was briefly debated this morning about this question of, well, what if his understanding was that Mr. Frenkel was going away, and it goes to the question of, as Mr. Buck put it, what is the property which is the subject of any perceived assurance? Or another way of putting it is, how does the remedy correspond to the alleged assurance or reliance? And if what Mr. Bell is saying, well, the position should be that it's him 49 and Inc. 51, it's very, very hard to see how any proprietary estoppel claim can get into a position where it's him and Mr. Lampert 50-50 and Inc. is out of the picture. So those were the key parts, and I should, I think, simply also take you to 38 to 40, which is his account of what has subsequently become characterised as the Frenkel disavowal, which is, one, him taking a phone call outside a pub, and then two, a conversation on the patio with Mr. Frenkel. And then in particular at 40, the way he describes his discussions with Mr. Lampert. And they're all discussions about the trading relationship, and it's the trading relationship between Inc. and the company. It's not discussions about ownership, which is, I think, consistent with the judgment in that respect. So there's nothing in any of that about a belief that ownership would or had changed. And indeed, to the contrary, there's a suggestion that he would have expected that ownership would not change. So that was his witness statement. And then I wanted to go to the transcript, which Mr. Twigger handed up this morning in A3.
Was this witness statement before our judge, Judge Jarman?
I think it was, in the sense that I think all of the witness statements and transcripts from the trial before Deputy Judge Tipples were there. What I would say is that in my submission, the proper approach to the evidence, and I think the approach that, in fairness to the judge, he appears to take in his judgment, is that while those things were there for information, and in particular were deployed from time to time in cross-examination, the evidence before him, strictly speaking, was the evidence before him and not... It's the difference between previous inconsistent statements and so on and what is actually evidence in the proceedings.
Except they would all be admissible now as hearsay statements if anybody put them in. And I don't know what happened.
No, I mean, Mr. Buck might make the point that his clients weren't party to the 2017 proceedings. So,
But these days, if it goes into an agreed trial bundle, it's deemed to be admitted. You don't need the formality of the hearsay statement.
that's right, my lord, although I think there might be a debate as to the basis on which it's deemed to be admitted. It's admitted, obviously, as evidence of what those people said before Deputy Judge Tipples. I'm not sure if that gives it the same status as testimony before the trial judge. But perhaps this is a debate we don't need to have, because I'm not suggesting that anyone shouldn't look at this. Indeed, quite the reverse.
Well, no, you're inviting us to look at it because you think it's got points helpful to you, and I'm just wondering what use the judge made of these things, and what use we can properly make of these things. But your submission is it was all before the judge, and he could look at it and make such use of it as he wanted to.
Yes, both trial 1 and trial 2, I think. Mr. Strelitz will correct me if he has a different view or recollection. My submission is that on any view, and this is what I principally rely on it for, the court can look at all this material as evidence of what Mr. Bell was saying in this case in 2017, in the same way that you can look at his pleading and see what he was saying in 2015, and you can look at his deposition and what he was saying in 2012. I'm not sure I need to go any further than that and positively argue that you should treat it as the same as witness statement or oral evidence in these proceedings. It's sufficient for my point that he said what he said.
Well, it's clearly not oral evidence in these proceedings unless he expressly adopted it in the course of examination, but we're not told that that was the case. But yes, I have to point that you can look at it.
Yes, yes. So this bit, which is actually a bit that as I had understood it, Mr. Twigger is relying on, but I will say helps me, is page 17. And it's lines 10 to 13 is really the key bit. So we're talking here about the 2010 discussion. And my question was, did you understand the legal ownership or rights on the US side had changed? And what Mr. Bell was saying in 2017 was, I don't recall. And then obviously you've seen his pleading and everything else, in which he was clear that his position was that it hadn't changed. And there is this point which was made by reference to the transcript about carrying on the business and subsequent growth up to 2017 and possibly beyond. But the key point about that is, on any basis, by 2011, Mr. Bell was well aware that Mr. Frenkel was asserting an interest. That's the date of the draft declaration. So if one is looking at reliance, or rather detriment, and of course I say you don't get there because he didn't have the requisite belief, but if you get there, the only period for which he can possibly have had the relevant belief is a year, and there isn't any suggestion or evidence that the position had so radically changed by 2011 that Mr. Bell was no longer in a position to walk away, if that was ever what he was going to have done.
Well, this statement does say that, looking at paragraph 42, turnover was increasing significantly, and that goes back to 2011. He seems to have given some oral evidence to Miss Tipples about it, because she refers to it in her judgment.
Yes. Yes, I mean, as I say, in my submission, one doesn't get to this, but it's hard to see again how the supposed detriment in that brief period would justify getting where the judge ultimately goes, which is a complete rearrangement of the shareholding.
What time period is he referring to in the first sentence? Because he's just referred in 41 to early 2013. And then the second sentence, he talks about the year ending April 2011. But is he saying there was an increase from the 2.9 million, or is the 2.9 million the increase?
The short answer is I don't know, my lord.
Lord, if you look at paragraph 33, sorry to interrupt, it may help.
So there is an increase, but not in my submission a change in order of magnitude if one compares at least those 2 years. In my submission, one couldn't say that that is some fundamentally different business. But as I say, one simply doesn't get to this. The fourth point, so moving on from the 2017 evidence, my fourth point of 5 was just to do with this, the possible question that Mr. Bell may have been thinking about or relying on something else. The first point is what I've just shown you in Mr. Bell's statement about his saying that if Roman or Ari left, his understanding was that he would have carried on with Inc. It seems to me that evidence is would be pretty fatal to any attempt to recharacterise the claim as being based on an understanding about who was staying and who was going. The other point is that that's never the way it's been pleaded or put. So if one looks again at the particulars of claim, which are in the core bundle at tab 12, paragraph 37, page 242. So it's paragraph 37.1, and the clear and unambiguous representation is that Mr. Frenkel no longer maintained an interest in LA UK, and that LA UK was to be beneficially owned by Mr. Bell and Mr. Llampert henceforth, and that LA Inc. was no longer a beneficial co-owner of LA UK. So it does, as I think Mr. Twigger fairly recognised, come back to the question of whether Mr. Bell did or didn't believe that Inc. continued to be a co-owner. And on that, it is, I say, really all about the subsequent conduct, and I won't reiterate what I have to say on that. So that was my fourth point. And then the last point is just to deal with Mr. Twigger's points from yesterday about the judge's approach to the evidence. The first of his points was to say that my arguments had been put to the judge at Trial 1 and Trial 2. And that is true, but it doesn't really answer the question of whether the judgment in Trial 2 deals with those points adequately or not. And Mr. Twigger's submission in relation to that was to take you to paragraph 33 of the judgment, which is where Mr. Buck was a moment ago. It's page, of the first judgment. So it's page 150 of the supplemental report. And it was paragraph 33 which identified the confusion explanation. But the key point about these paragraphs, beginning at really at paragraph 30 or 31 and running through to paragraph 35, is that what the judge is doing here is he's dealing with Mr. Bell's credibility. And that's why this passage culminates in 35, where he concludes, he effectively acquits Mr. Bell of being a liar, but he says that he was confused, and that's the basis for adopting what the judge describes as the cautious approach. And that's the approach that one sees in paragraph 27 and paragraph 45. So all that Mr. Twigger took you to in this regard, all that establishes is that the judge was finding that Mr. Bell wasn't a liar, but that his oral evidence wasn't reliable. So what actually matters is the next stage, which is whether and how the judge dealt with the evidence that he could rely on, namely the documentary record. It's a neutralisation of a suggestion that Mr. Bell might be lying, but it's not an answer to my point that the judge's findings are unsupported and unsustainable. And in that regard, Mr. Twigger's repeated statement yesterday was to say that there is evidence going the other way on these points, and to remind your lordships that this court has not seen all the evidence. Now, of course, that's not how Mr. Strelitz put it in closing before Deputy Judge Tipples. He described Mr. Bell's evidence as steadfast and very definitely not going two ways. But there are really 3 points on this. First of all, Mr. Twigger says that the judge relied on his assessment of the witnesses in cross-examination. We've just been dealing with that, and his assessment in cross-examination was that he couldn't place particular reliance on the evidence of the witnesses. And we've just seen that passage in the 2017 transcript where Mr. Bell said that he didn't recall what he thought in 2010 about whether ownership had changed. So while the judge is undoubtedly entitled to make an assessment of the witnesses, in this case, his correct assessment was that the witnesses weren't very useful. And it follows from that one can't rely on anything Mr. Bell said as supporting the conclusion. The second point is that there's no evidence identified in the judgment which points the other way, i.e. to a belief on the part of Mr. Bell that LA Inc. had abandoned its interest. And regardless of what may have been in the trial bundles or anywhere else, for the judgment to stand, there would need to be evidence identified in it on which the judge could properly rely. And in my respectful submission, there simply isn't any such evidence identified, and Mr. Twigger is not able to point to any. And then the third point of 3 on this is that Mr. Twigger himself didn't show you anything of substance that was before the judge, although not mentioned in the judgment, which could have supported the findings. He showed you one piece of friendly cross-examination from Miss Ansell QC, acting on behalf of Mr. Lampert, but that went no more than the question of the splitting of profits after 2010. And there's been plenty of time to prepare for this appeal. The reality is, if there were some evidential support for the proposition that Mr. Bell actually thought in 2010 that the interest had been abandoned, then it would have been produced, and it hasn't. And so when Mr. Twigger says there's a danger of island hopping here, if one steps back and thinks about it, in my submission, at least as regards his case and supporting the judgment, you aren't island hopping because there is no dry land on which this judgment can be perched. The evidence is just not there. And then the final area to deal with were two questions which my Lord Justice Arnold asked about the sharing of profits after 2010. First, that payments to Mr. Lampert must have been in respect of Inc.'s position as shareholder, to which Mr. Twigger's response was, no, the payments tell you a lot about ownership. And second, that any agreement about profit sharing could have been implemented without changing the ownership. And again, Mr. Twigger seemed to say no to that. Well, I perhaps don't need to take you back there because we went there more than once yesterday, but the answer to both of those points is what Mr. Bell said in his 2017 defence, which was the point about Inc.'s sum. It's very clear that the position adopted was that the payments being made to Mr. Lampert were in respect of an interest that was still held by Inc. And it's clear from that, and indeed from the pre-2010 arrangements, that Mr. Bell entirely understood, and it was entirely possible, to distribute Inc.'s share of the profits to somebody else, effectively as the assignee or directed party of Inc. So in my submission, those points don't go anywhere. Now, unless I can assist further, I've nothing else to add.
Thank you very much. Oh,
I
sorry.
was just going to say, just on that last
Yes.
point, I think Mr. Bell's evidence, I have to point what's in the pleadings, but I think Mr. Bell's evidence was that he gave 50% of the distributions to Mr. Lampert because he took some advice, and the advice was, well, if they're the registered shareholder, they're the people who ought to get it, which is a slightly different take on why he was doing it.
It is a slightly different take. It's not what's pleaded. His pleaded case is clearly that you could do something different. It's not an answer to the arrangement they had between 2004 and 2010, which was clearly a direct payment to the individual shareholders of Inc. And in any event, I would submit that on a fair reading of that evidence, what he's actually saying is he took some advice, and they said, well, given that Mr. Lampert is the registered shareholder, there ought not to be a problem in paying him, which is correct because Mr. Lampert was the trustee. So if it is paid to him, there is an obligation for him to
It's his
account
problem and
for
not
it.
Mr. Bell's.
Put shortly, yes. Exactly. But what that doesn't mean is that Inc. has ceased to be the beneficial shareholder.
Yes, thank you.
So in the end, I say all of this is actually quite simple. The actual question is, did Mr. Bell think that Inc. had lost its interest? And the answer is no. And one doesn't have to look further than that.
Yes, thank you very much. Now, I think, Mr. Twigger, you're entitled to a reply on the cross.
Yes, on the constructive trust. I think that's right. I think I can be brief. The two Australian cases, I confess I'm not sure I've fully understood them. But the point from the DKLR case seemed to me just to be a statement of the rule that we all accept, that one person can't be a trustee for him or herself. And in my submission, that really doesn't add anything to the debate. As I understand the Corrin case, it's about a situation in which somebody was going to create from the outset a trust where A conveys on trust to B, and B is intended to hold on trust for A. And what was being said was, well, that doesn't make any sense. You can't get through that kind of charade. It's being created from the outset. That's obviously a different situation from one in which there already is a trust, A holding on trust for B, and B then disposes of his or her equitable interest. So in my submission, those cases don't actually advance the argument at all. On the consideration points that my learned friend made, I was surprised about the submissions in relation to whether there's a contract or not. I'd been working on Mr. Buck's skeleton, core bundle, tab 3, page 113. Paragraph 10, Mr. Buck saying, Mr. Bell and Mr. Lionput entered into a new arrangement. Properly considered, it was a quadripartite arrangement with Bell and Lionput acting for themselves and UK and Inc. respectively. As part of that 2010, and he defines that as the 2010 agreement. As part of the 2010 agreement, the preferential component, the trading component came to an end. The profit sharing component was also restructured, he says, I would say. Came to an end and a new agreement was reached, but it doesn't much matter. So my understanding was it was common ground that there was an agreement in those terms, and it was a quadripartite agreement to which they were all parties. The only question is what was to be implied into it, if any. My learned friend Mr. Barden made some pleading points about what was pleaded and so on. On that, I just wanted to draw your Lordship's attention to the fact that all of that was raised in the Court of Appeal on the previous occasion, so that the points that were being run before His Honour Judge Jarman on this occasion were points that the Court of Appeal previously remitted to him. And in paragraphs 57 and following the Court of Appeal's judgment, I don't think your Lordships need to actually look at it now, but you'll see that there was a pleading argument, and that was dealt with by the Court of Appeal at quite some length, and they concluded that we were able to run these points, and those were the points that were remitted to Judge Jarman. So the position had moved on somewhat from the pleading that my friend showed you. Mr. Barden's point about the contract for something to happen in the future and constructive trust not arising, he's talking about sort of exchange and completion situation, and constructive trust not arising on an immediate disposal. We'd say that's obviously contrary to Neville. Neville was a situation in which there was no exchange and completion or anything like that. It was an immediate disposal, but it didn't fail for lack of formality there. So we say there's nothing in that point. Sorry, would your Lordships just give me...
Yes, go ahead.
Rules, unless I can help you further, that's all my submissions.
All right, well, thank you very much. We will reserve our judgments in this case. I suppose that comes as any surprise to anybody. They will be sent to those whose names have been put forward in draft, with a view to any typographical or minor factual errors being corrected. We would hope that in the light of the judgments you will be able to agree an order. If you can't, then please make short submissions in writing on anything which you're not able to agree on, and we will deal with them without a further hearing. The judgment will then be handed down remotely, so that there will be no question of any attendance. I need to draw your attention formally to what I'm sure you're already aware of, which is that there is a strict embargo on the draft judgments, which the Court of Appeal takes very seriously in the event of any breach. Thank you for the wide-ranging and interesting submissions. That concludes the hearing.